Welcome, and thank you for joining us for today's presentation. Our topic is what employers should know when employees start returning to work, the new normal. We have just a few announcements before we get started. Please note that this seminar and all of the accompanying materials are protected by copyright, and that the entire seminar is being recorded. Also, please note the material presented by our speakers at this program has been gathered for general informational purposes only. You can submit questions during the presentation by utilizing the Q&A tab in your WebEx screen. Our presenters will do their best to answer as time allows. Without further delay, I'll hand it over to our presenters.
Good afternoon and welcome. Before we begin, we would like to thank the Business Development Board of Palm Beach County for making our presentation to you today possible. We're going to cover two primary topics today: implementing policies and procedures for returning to the workplace, and possible legal exposure related to employees returning to work. Before we get into the details, there are 4 laws that you should pay particular attention to when you're reopening. The first is OSHA. That particular set of laws relates to providing a safe working environment for your employees. The second is the Families First Coronavirus Response Act, which was recently enacted as a result of the pandemic and relates to paid sick leave and expanded FMLA leave. Third is the ADA, which requires reasonable accommodations for employees who have a disability that puts them at a greater risk if they contract COVID-19. And finally, the NLRA, which protects employees from adverse employment actions when they engage in protected concerted efforts. For instance, if the employees were all to get together and refuse to work based on the fact that they believe the work environment is unsafe, even if that belief is wrong, as long as they've made that assertion in good faith. The state of Florida recently entered into phase 1, with the exception at the beginning of 3 counties on May 4th. Palm Beach County is now in phase 1 as of Monday. And what does that mean for Florida, including West Palm Beach? Well, it means that restaurants can reopen, but they need to follow special rules. Retail stores can open on a limited basis, at 25% indoor capacity. Elective surgeries can resume. Thankfully, hair salons, nail salons, and barber shops may reopen for those of us who need some personal care, but obviously they also have to follow certain rules. Schools remain distance learning only, which may create some problems for employees that are returning to work, which will be discussed later. Visits to senior living facilities are still prohibited, and pharmacists can now administer COVID-19 tests, which is far more convenient. There's a couple of questions that are frequently asked when we talk about phase 1. Employers are always concerned about whether they're required to do temperature tests, whether they're required to provide masks for employees. The phase 1 order that was entered by Governor DeSantis, it doesn't list masks or temperature check requirements. Some businesses have put protocols in place to do those things. And when you're considering whether you're going to need to have masks or you're going to require masks as an employer, you always need to keep the OSHA guidelines in mind. you should check the OSHA website and you should see what type of business risk you have related to COVID-19. Most people fall into the low risk category, which would require PPE like it would for somebody who, for instance, is in the healthcare industry. Will businesses be subject to being fined? Yes, they are subject to being fined if they violate certain of the phase 1 rules, but there are questions as to whether those are actually going to be meaningfully enforced. And finally, when can we expect phase 2? Well, no one really knows. Governor DeSantis is going to look at the numbers and consider with his task force when that would happen and what those provisions would be. What will it look like? Well, the Florida task force has at this point indicated that they would probably recommend that bars, nightclubs, and other businesses could reopen in phase 2. Gyms will probably reopen with some type of capacity. And restaurants will probably have less restrictions on them depending on how things go, along with some of the other service industry businesses. Returning to work plan benefits. Well, first, let's talk a little bit about what a return to work plan is. It's a plan for employees to safely and successfully return to work. It's going to detail how the workers will gradually return to the workforce and any job-related specifics, and it should be tailored to your organization and employee specifics. For instance, there are certain companies that have already started returning to work, and they've put together certain specific guidelines related to steps for cleaning and disinfecting equipment, staggering shifts and lunch breaks, setting up a pandemic response team, establishing on-site health screening, and we'll talk a little bit about that in more detail later. But there are certain benefits to doing a work plan, return to work plan. First, it acts as an invitation to your employees to return to the workplace. It increases your line of communication with them. It reminds them that you're still there and that at some point they're going to be returning to the workplace. It makes them feel supported by their employer, that you're thinking about their health and safety, that you're thinking about bringing them back. It increases your engagement with those particular employees, which will probably lead to less fear and uncertainty for them when they're returning to the workplace, because they know there's a plan in place and they've been advised of some of those guidelines. And it also, studies have shown that returning to work with a return to work plan improves the productivity for employees, because they know what to expect before they get to the workplace and they know what's expected when they get there.
Heather, just as an example of a very detailed return to work plan, folks can go on to Cushman & Wakefield, and you can download and take a look at their guide to recovery readiness that's readily available on their website. So if you're looking for a sample, you might want to take a look at some of the considerations that they have made. It may help you in doing your own. Sorry.
Thanks, Diane. So what do you need to do first? Well, every pandemic plan should have a team coordinator, because you need a leader or a chief for all of the people that are going to be on your team. It really depends how large you want that team to be. You probably want it to be about a handful of people. You're going to assign defined roles related to the preparedness for people to return to work. You want to make sure that you're including at least one person that has knowledge of employment issues such as discrimination, ADA, likely someone from your HR department, and develop a communication system so that information is transmitted that's critical to the team members quickly and accurately. For instance, if someone were to test positive from the workplace with COVID-19. So one of the first things you want to consider is, what is your recall plan going to be? What is the first day that employees are going to return to the workplace? Are you going to do a phased return? And when you consider doing a phased return, you need to keep in mind that you cannot have a phased return that's based on discriminatory reasons. For instance, you wouldn't want to say that everyone over the age of 60 and that has an underlying health condition will not come back to the workplace. You can't make that assumption. You need to treat everyone in a non-discriminatory manner. So you want to base your phased return on the essential functions of your business. For instance, who are the essential employees? Can they continue to work remotely? Do they need to be in the workplace? What is the nature and function of their job? Are you just going to call back the people with seniority? Perhaps you have several different groups of employees, and at first you're just going to call back all of the managers. Do you have certain employees that just have to be in the workplace and are essential? How are you going to know if those employees are intending to return to the workplace? There may be a lot of reasons why people don't want to return. They may have child care issues. They may have underlying health conditions. They may be caring for someone with COVID-19. So you're going to want to have some kind of either acknowledgement form that you send out to employees or other communication where they affirm whether they are planning to come back as scheduled under your return to work plan. And then, of course, you want to keep into consideration accommodating vulnerable employees, especially if they might fall under the ADA guidelines. You want to make sure that you're having, if they raise an ADA related issue for returning, that you're having that interactive discussion with them, that you're asking a lot of questions, and you want to consider whether there's a special accommodation, for instance, if they can continue to work from home for some period of time. When you return to work, everyone needs to keep in mind that the Families First Coronavirus Response Act is still going to be in play through December 31st of this year. Remember, if you have less than 500 employees and you are reopening and bringing them back from furlough, or you're doing new hires, you're going to have to contend with the FFCRA. First thing that you need to make sure that you do, since we've all been working remotely for the most part or not working, is that to make sure that you post the notice of rights in the workplace. This is a copy of the poster, and it's available at the DOL, Department of Labor website. If you don't have employees that come to the office regularly or don't work in the office, you want to make sure that you're communicating this flyer to them so that they know their rights, either by email or some other communication. And just generally, It has provisions for emergency paid sick leave for up to 2 weeks after the first day of work. It has expanded family medical leave for child care issues after 30 days of employment. And there are tax credits for employers that make payments under those 2 provisions. Who's exempt? This is outlined more particularly at the Department of Labor website, but generally small businesses can seek an exemption if they have fewer than 50 employees. In doing so, they're going to have to establish that providing child care related paid sick leave and expanded family medical leave would jeopardize the viability of their business as a going concern. And there is some more guidance on the Department of Labor website regarding that. I mentioned the website earlier. As you can see, we have the website posted there. You want to make sure that you stay attuned to new guidance by the DOL and the EEOC because things are changing all of the time. And you see the DOL website there. Remember that the frequently asked questions or facts that are posted on the DOL website, those are guidance only. They are not the law. So if you have concerns regarding the answers to some of those questions, or you have questions related to those issues, you want to make sure that you contact, an attorney that can discuss those issues with you. Now I'm passing the ball over to Diane. And she's going to talk about what if employees don't want to return to work.
Hi, good afternoon, and thank you all for joining us. I see some of you have already found the Q&A box on our site, and we'll try and get to your questions. If you have any, please post them. If we don't get to them before the end of our webinar, then we will email you directly if we have your email address and try and answer them then. I want to just make one clarification because one of the issues with the FMLA is the 50 employees. Well, this one actually takes it down to 25 employees. So if you have less than 25, you have to prove that it would be a hardship. But if you have 25 or more, you're actually covered by the statute. In addition, when you're posting it, if you don't have the ability to post it, as Heather said, you can email it. If you have an intranet is also a good place to post this so that employees have access to it. I would not wait. I would put it up now if you haven't already, or get it out to your employees now. It should have actually been out when the law was originally adopted. So we get a lot of questions about employees refusing to return to work or refusing screening. And, because of whether it's the pandemic fears, we hear a lot about the fact that they're making more on unemployment, so why come back? Child care concerns and vulnerable employees and reasonable accommodation. So just to touch on them a little bit, part of this is all about documenting. Those of you who know me know when I talk about any type of an employee issue, the first question is going to be, what kind of documentation do you have? So that's the same case here. You need to be able to ask questions and then document the answers. See if there's steps that you can take that right off the bat to help them allay their pandemic fears. Communicating your plan. We're going to have everyone wear masks. We're going to have everyone social distance. We're going to have hallways going in one direction only. Those types of issues communicating them to your employee is going to help you. In terms of an underlying health condition, if they decide to identify that, you need to be prepared to look at it. Now, in the past, many employers just say, oh, well, we don't allow remote working. Where that might have been a good answer in the past, it may not be a good answer anymore, especially where you've had your employees working remotely for the last couple of months. Another question to ask is, gee, what have you been doing? Have you been going out to the supermarket? Have you been going to get your hair cut now that we're in phase 1? What other actions have you been taking? And some of that will help you determine whether these fears are realistic or just a reason not to come back. Don't just assume that they don't want to return. They may want to return, but they need some assurances. One other question in terms of accommodating employees, the accommodation levels are a lot less if they are not in a public-facing position. That's why, as Heather had suggested, that you look at OSHA, you look at the Florida Department of Health, you can look at local departments of health to see what's required. In some cases, you may have an obligation to accommodate them if there's some objective evidence that they could be exposed to infection. But in terms of requiring masks, definitely, if they're public facing, that's a good idea, and OSHA does suggest. If the employer can establish that there's really no basis, and that's a bit challenging under both the ADA and the NLRA, and just to go back to that, that's the National Labor Relations Act, and please don't think that because you are not a union shop, it does not apply to you. It absolutely still applies to you. When employees are getting together for their common good, it is going to apply to you. And I've had that happen already with some of my clients where employees, in one case, there were people within a factory who came down with COVID, and the other employees were afraid to go back to work. The employer has since met with them, talked about what we can do to allay their fears, and has been able to move it a step forward. Remember also that if somebody's complaining about an unsafe condition, OSHA prohibits retaliation, so you need to be prepared to engage in that conversation. An employee does have a limited right, though, to refuse to perform an assigned task if it's objectively reasonable, or their apprehension, unless their apprehension is objectively reasonable. So it's, and there's no less drastic alternative available. But generally speaking, there's no right for employees to walk off the job. There may be also other implications of ADA accommodations where certain tasks they can't perform or they feel is becoming more vulnerable to them because they have an underlying health condition or they have their age. But once again, don't assume that just because you know somebody is over the age of 60 or they have some other health condition that you're aware of, do not assume that they don't want to come back to work. As Heather mentioned before, and I'll talk a little bit later, that results in a discrimination charge. In terms of the federal pandemic unemployment compensation, that's where your employees are getting, or you are getting, an additional $600 a week under the existing state unemployment. That started March 27th. It's going to end July 31st. It was an attempt to assist employees who are unemployed because of the pandemic. And for those that were not otherwise eligible for unemployment compensation, that, by the way, ends December 31st. So those are consultants and people like that. In terms of what you do if somebody doesn't want to come back and they don't have reasonable fears or a reasonable reason, and you can't accommodate their reason. Well, unemployment compensation, you may have heard there's been a little bit of confusion in Florida. about whether employees have to officially start looking for work yet or not. The last time I looked at the website, as of this Monday, they were supposed to go back to reporting every 2 weeks. And you as an employer have an obligation under the law to report the fact that you've offered someone to return to work and they have declined to do so. Now, that may or may not stop their unemployment, but then the decision is not yours. Especially if you have documentation, as Heather talked about, getting a signed acknowledgement whether they're coming back. The offer needs to be for the same job. It needs to be for the same amount of compensation and generally the same number of hours in order to disqualify them. You have to deal with childcare concerns. The fact is that school is still not in session. Many camps will not be opening this summer or will be opening much later. But realize it's not just that the fact that the camp isn't opening, it's the fact that there is no one to care for the child. So you can ask for some specifics about that and take a look at that issue, whether that's a reasonable reason not to come back. Heather and I just dealt with an issue with an employee an employer who was getting ready to recall furloughed employees, and they were indicating that they don't want to come back to work. So one thing to look at, because of childcare, one thing to look at, though, is whether or not the EFMLA, that extended FMLA, is going to apply if the person has not come back to work. Take a look at the guidance. We think that there is some possibility that it won't apply to them unless they came back to work. And then vulnerable employees, as Heather said, you want to engage in that interactive conversation, but realize that in the past where you may have said, no, you've got to come back, you can't work from home, your job can't be done from home, that there's a whole different argument now, because for the last 6 or 8 weeks, they have in fact been working from home. Let's talk a little bit about safety, a little more about safety practices. As Heather mentioned, there's the CDC guidance, and you can find it at this site, and the OSHA guidance. You're going to need to be acting consistent with the ADA. However, the other place to look is the EEOC, and both the EEOC said under the ADA that you're allowed to do certain screening as long as it's consistent with the CDC and public health authority. So that's where you're going to be able to take temperatures and ask questions that maybe would have been protected in the past under private, health information that you weren't allowed to ask. We talked about creating a COVID-19 or a return to work team. Well, part of that is also creating an infection control protocol. That's really important. It's important for you not just to do that for your own business sake. It's really important to do that for your employees, for your business reputation, and to encourage employees to come back to work communicating that infection control protocol is really, really critical. So some examples of an infection control protocol. We talked about, and everybody knows now about creating that 6-foot work area. Well, that may require re-engineering of your office. I know in our case, we're going to be moving some of our support staff around in order to be able to meet that 6-foot area. We're going to be using some rooms that might have in the past be used as conference rooms to be employee workplaces in order to meet that 6-foot area. You're all familiar with it in terms of the distances, and depending on the kind of business, you may need to be taping the floor, putting up arrows as to which way to go, putting an ingress and an egress. In other words, come in one way, go out another way. You want to reduce the common area traffic. In addition, you may have to close your lunchroom or close your, not have the coffee available where everybody can go up and touch the coffee pot. It's a whole new way to have to deal with this. People may have to be bringing in their lunch, but they may or may not have access to refrigeration or hot water. All of that is issues that we're going to have to work around. Administrative type protocols. You've heard over and over again on the news about limiting gatherings to 10 or less people. That's why we've all become much more familiar with Zoom and WebEx and other online meetings and online webinars. You may also want to reduce the number of employees coming in at any one time. You have staggered shifts or alternating days where people come in and can work from the office. Other days they may be allowed to work from home. It may be a staggered return to the office. You come in Monday, Wednesday, and the other person comes in Tuesday, Thursday, and Friday, depending on need. You may want to consider putting up plexiglass, but that's back at engineering. You may want to minimize non-essential travel still and adherence to the CDC guidelines regarding isolation after travel. Cleaning and safety, hand sanitizer at every entrance and exit and throughout your facility. Provide those employees with disinfectant wipes, and I know they're hard to get, but I've been told that they're becoming more available. So you want to have that available so that they can clean their phones or clean touch areas. Have your cleaning staff clean touch areas regularly, clean the bathrooms more regularly. Providing tissues to your employees, and I've seen where it's people are leaving doorways open so that folks don't have to touch the handles. And then of course, really important is to have that cleaning protocol if someone turns up sick. How to deal with that situation, because you're going to have an issue with the rest of your employees getting nervous. So another thing we've talked a little bit about is screening, and some of the examples of screening you're going to be able to do are measuring temperatures. And recently I was asked about I guess it's almost an automatic temperature taking machine where the employee steps in, their temperature gets taken, and then they step out. But this particular machine that they talked about has a red light flashing and a sound flashing if someone tests that their temperature is over the 100.4 CDC guideline. You definitely don't want to do that. It needs to be private. You need to be making records of it. I recommend record keeping on taking of temperatures. You have one person designated. It's done in a private fashion. Not everybody is standing on top of each other. And if someone does come up with a temperature that is above what is expected, then you want to have a separate discussion with them. So touchless thermometers or scanners, using that CDC guideline, scanning in a private location, keeping the temperature records confidential, all part of what you're going to need to adopt if you're going to measure temperatures. The other issue is how long is that line for an employee to get in to have their temperature taken? Some states are requiring you to pay the employee the moment that they get online in order to, that's on the job, almost like the donning and doffing decisions, that if it's mandatory, then you may have to pay them for that time. Or you may have to figure out a way to make it a little bit easier for people not to stand in long lines to have their temperature taken. As it is, for instance, in our building, we've been told when we come back that it's going to be 2 people on an elevator at any time. Well, that's going to take a long time to get up into a building with 20-odd stories. So think about that in terms of maybe staggering your workforce time. A health questionnaire, that's something also that you're able to do that in the past was not particularly encouraged. In terms of what kind of questions you can ask, I think I go into that a little bit further on in this presentation. You want to monitor your workforce for symptoms, and you've probably seen that there's policies for contact tracing so that if one person in your office comes down with COVID, that you're able to trace who they were in contact with. I know Heather and I were talking about it the other day, and she mentioned that there is some type, I think, Heather, you said like a watch that people would be able to use that will record who they have contact with. A little frightening, but I suspect that there's going to be other ways that we're going to be able to do contact tracing. And you want to have policies for those employees who have been exposed. So we talked a little bit about the temperatures, which is a brand new thing under the EEOC, under the ADA. So you should be aware also that some people with COVID do not have a fever. So even though you're doing temperature screening, if somebody has other types of symptoms, you want to be aware of that. So you've got basically two strategies. You've got this non-test-based strategy that, and what you want employees to do if in fact they have symptoms. Don't be afraid, by the way, to send somebody with COVID symptoms home. In the past, employers did not do that. So you want to have either a non-test-based strategy as to how to deal with those folks with symptoms, or you want to have a test-based strategy where it's a confirmed test. And this all has to do with how soon somebody can come back to work after they've tested positive, or they have not had a test, but shows the symptoms of COVID. And here's some other information about employees who've tested positive or have been exposed and what you may want to require in terms of self-quarantining. You can ask employees to sign a certification questionnaire that basically matches these requirements. Have you had any symptoms within the last 10 days? Were you exposed? Has it been at least 3 days since you've had your last fever? Has it been 7 days since the last symptoms first appeared? And I suspect as we know more and more about COVID, and there are new symptoms, unfortunately, that are starting to come to light, we may have to add more questions to that, or you may have to have more awareness with regard to that. I think, Heather, I think it is back to you.
I am up. So Diane talked a little bit about record keeping. Let's talk a little bit about the EEOC first, since that's the simple one. As she mentioned, an employer may keep a log of the temperature checks, but you have to keep those logs confidential unless they're being disclosed to the public health agency when the company learns of an employee who's tested positive for COVID-19. Any medical records that you're keeping obviously should remain confidential, and they should be kept separate from the ordinary. They should be kept separate from the ordinary personnel file. So you want to have a separate folder where you're keeping any health information that you're tracking regarding your employee. A little more complicated are the OSHA guidelines for record keeping in the event that somebody tests positive for COVID-19. Under OSHA's recording requirements, COVID-19 is a recordable illness, and employers are responsible for recording cases of COVID-19 if The case is a confirmed COVID-19 case, as defined by the Center for Disease Control. The case is work-related, and in that particular case, work-related generally means that if the event or the exposure occurred in the work environment and caused their resulting condition. In some cases, it may be more difficult to determine that. If you are, for instance, a healthcare worker or you staff healthcare workers, it might be easier to say that they were actually exposed to COVID-19 at work, as opposed to if someone is working in an office environment where they don't come in contact with people from the outside or other coworkers very frequently, and they're also doing things outside of the workplace, like going to the grocery store, going to the salons that are now open. So that determination might be a little more complicated. And third, the case involves one or more of the general recording criteria. Those criteria are, for instance, the employee passes away, they're forced to stay home from work for days, they've sought medical treatment beyond, for instance, a first aid at work, or they've lost consciousness. So the OSHA requirements are a little more complicated and are going to require some analysis in the event that you have a COVID-19 positive case. COVID-19 protections, we've talked a little bit about that. You're probably going to want to post CDC signage at your office location, in several locations, just to act as a reminder to people of how they should be behaving in this new environment. You want to encourage workers to stay home if they're sick. Remind people that, maybe they shouldn't just sit down at someone else's desk or use somebody else's materials like their stapler. All things that we're kind of used to doing in the workplace that are completely changed by the pandemic. You want to make sure that work areas are being kept clean. You may want to give, wipes to your employees. And you might want to also remind people that handshaking is not, fortunately, acceptable at this point. So you may want to create a new greeting, whether that's, a wave or possibly, an elbow bump, although that's that requires you to get closer to people than perhaps just a wave. And Diane covered most of these already, the OSHA workplace controls. You just want to make sure that you have good ventilation and that you're putting into place protections that are keeping social distancing in mind. Face masks, we get a lot of questions about that. In particular, whether face masks are required, whether the employer has to provide them, whether they have to provide gloves, and those types of things. You need to go back to the OSHA guidelines and see, based on your business, where you fall within the risk category. Generally, if you are in an office setting where you don't have outsiders coming to the office and meeting face-to-face with your employees, and you're practicing social distancing, you're going to be in the low risk category. Under the executive order that was entered by Governor DeSantis, there's no requirement that face coverings be provided to employees by the employer, or other protective equipment. You know, under the OSHA guidelines, if you fall within that low risk category, there's no PPE requirement. And in fact, you know, the EEOC has said that, you know, generally you don't need to have those types of things provided to your employees. Can you require it? Yes, an employer may require employees to wear personal protective equipment during the pandemic. However, you may want to consider what the ramifications of that are carefully. First, there may be people who need an accommodation that are disabled, for some reason cannot wear a mask, so you want to make sure that you are doing that interactive process that's required with them in the event they raise that issue. And in addition to that, if you were requiring them to provide, to wear a mask, generally you would be then required to provide that protective equipment like a mask because you are requiring them to wear it. And if you are going to require face coverings, you want to make sure that you are outlining to your employees in your protocol exactly when they're expected to wear the mask. For instance, do they have to wear it all the time when they're sitting at their desk in their office and they may not be coming into contact with people? Or are you expecting them only to wear it when they're walking down the hallway? These aren't things that we would normally think about, but certainly you want to be detailed about what you are requiring your employees to do so that they're clear as to what the protocol is. And this slide just discusses what I've just indicated. There may also be some religious beliefs that come into play with the masks and protective equipment. And if you are going to require a mask, you may want to have an accommodation request form, which would be a more simple process for employees when they want to raise an issue regarding the wearing of a mask, rather than having phone messages and people coming to your office in HR all the time, raising these issues and asking questions. Prior to return to reopening, as we discussed before, it's very important to communicate to your employees what the policies are going to be and what the expectations are from not only a return to work perspective, timing-wise, but also with respect to any protective measures that you're putting in place. You want to make sure that you are training your supervisors or managers regarding any discrimination or retaliatory behavior risks. As Diane mentioned before, you want to be very mindful of people who are requesting accommodation. You want to be very mindful of groups of employees who have indicated that they don't feel safe in your workplace, because that could implicate the NLRB guidelines. And you want to try to nip any potential discriminatory or retaliatory behavior claims in the bud, because there are certain attorneys that are already advertising about these types of claims and bringing them against employers. And Diane's going to talk a little bit more about that.
Yeah, before I get into limiting the legal exposure, I just want to mention, when you're doing your plan for return, you want to also determine how you're going to deal with vendors, how you're going to deal with in-person meetings in your office, whether you're going to eliminate them, limit them, what questionnaires or what you're going to ask your clients or customers if you feel the need to, or you're going to require masks. When you're dealing with vendors, you might ask them what their policy is. regarding their employees, and I probably would want to set up a protocol for how deliveries come in, where they come in. You know, you may not want them to come to your floor. You may have one of your support people meet the delivery person down at the loading dock and bring the supplies up themselves. So let's talk a little bit. We've talked on it several times about discrimination, avoidance, and all of this is not anything that should be new to any of you because it's applying testing policies equally. Don't pick and choose. Base your policies on official guidelines. That's easy. Think twice about terminating employees who raise workplace safety issues because you've got an OSHA retaliation and you have potentially a whistleblower issue. And of course, again, be open to reasonable accommodations. Remember, I think we're going to see a rise in lawsuits related to vulnerable employees. If you haven't equally made an offer to return to them because of either fears out of absenteeism or assuming that they won't be able to work or they won't want to come back, might get an age discrimination claim from them if it's older individuals, a disability discrimination claim if you're aware of an underlying health condition and that in and of itself has resulted in you making that determination not to bring them back. In terms of people that you have made offers to, we go back to that guidance, and again, it's a guidance. And you know, I want to talk about the fact that if you've made an offer to an applicant who now is testing positive for COVID and can't start, can you revoke it? You can. Before I go forward, just caution on discrimination because we're still seeing some national origin discrimination against Asian employees due to the fact that they're Asian and the belief that this has come from China. So be aware of that. Applicants who test positive don't necessarily, you can revoke your offer to them before they start if you need somebody to start right away. However, you can't terminate an existing employee who tests positive because then you're looking for a lawsuit under ADA. The original FMLA will still apply. So just because we have the EFMLA relative to child care, the FMLA that we're all familiar with will continue to apply. Be careful how you're selecting who you're returning. Base your policies really on the essential needs of your business, as Heather had said. Remember that you're going to have to provide the Families First Coronavirus Response Act, so that's the paid sick leave up to 2 weeks, and the extended FMLA that we've talked a little bit about. There's a lot of guidance on the Department of Labor website. I want to talk a little bit more about the workers' compensation and this willful and wanton conduct. And I know we're starting to get to the end of our time. I think this is really important because we've already seen one lawsuit filed against the retail giant who had an employee die after contracting COVID. And the accusation is that the employer failed to adequately screen and protect workers. This was an employee who was near them, working side by side, who came down with it, and then this gentleman was an older gentleman who contracted it and subsequently died. So in this case, the way that the attorney who filed the lawsuit is trying to remove it from workers' comp, because usually workers' comp is the sole remedy, is they're showing negligence and as gross negligence and a wrongful death. And as a result, they're going to try and press it under the employer liability section, which takes away the limits and the types of claims that can be made. So we're probably going to see more suits coming and attempting to prove that gross negligence. So that's why as you're implementing your worksite policies, keep a record of them. You know, implementing that social distance, in this case, they're alleging that wasn't done, that the store wasn't properly cleaned, that the employees weren't given masks and gloves and wipes and other protective equipment, and that there was no screening. Now, let me just mention to you that under the EEOC, you can now test or require an employee to test for COVID-19. But realize if you're going to do one of those quick tests in your work site, it's only good for that particular moment. At that moment, that person did not have COVID, but that doesn't mean that they don't develop it the next day. So you have to decide the value of those tests in your business. A couple of other issues that we're expecting to see litigation come from are the Fair Labor Standards Act, with all of your employees working from home during this period, you know, in particular your hourly employees. How have you had them recording their hours? Let's make sure that you have that you keep a record of that. So you're not dealing with unpaid hours, unpaid time, unpaid overtime. It becomes much more challenging in a remote environment. But if you haven't thought about it, please do. Loss of exemption as you're bringing back employees, if you're bringing back your salary people first, and all of a sudden you now have them doing jobs that would be normally done by an hourly employee. Think about that, because you could actually lose the exemption based upon that change in duties. Also realize you can't adjust the salaried employee's salary every week. So, oh, well, I only had you come in for 3 hours, so I'm going to pay you, or 3 days, I'm going to pay you 3/5 of your normal salary. You can't do that on a week-by-week basis. Last, just quick mention is commission sales and retail. If the commission drops too dramatically, you may all of a sudden be violating the Fair Labor Standards Act. And the same thing with outside sales. If they're no longer doing outside sales, then you may lose the outside sales exemption that you've been using for that. So real quickly, I'm just going to run very quickly through these because we've talked a lot about it. Review your state and local laws. They change. Keep up to date on them. Keep up to date on OSHA and Department of Labor. Understand your customer, insurer, and landlord requirements. Also understand what your landlord is going to do and what kind of cleaning protocol, and have a discussion with them about that. Assess the risks of your employees, and you may have to relook at your handbook. Now's the time to make some changes. You want to draft policies and procedures to mitigate and minimize risk. Are you going to require any kind of health screening, social distancing, limits on travel, personal protective equipment, and realize that, you know, those masks that we all see advertised on the internet, on television, on Facebook, are not necessarily, most of them are not PPE because they're non-medical, so technically they are not OSHA regulated and can only be used in environments that don't need that regulation. Communicate, communicate, communicate. Tell the employees what's happening. Tell them all the good things you're doing to protect them. Draft a review if you have an accommodation request form. Make it easy for your employee to request an accommodation. And then you may want to revisit your attendance and call-in procedures prior to having people come back. Look at your EEO policies. We talked about training your managers, all really important. You don't want them having to misstep just because they weren't aware of what the law is and what their requirements are. Have a point contact for COVID questions so that they don't have to go to their supervisor, then their supervisor goes to their manager, then their manager goes to the COVID king or queen. So you want to have a point of contact. Hang up that poster, send out that poster, make sure that you're doing that. Under the FFCRA, your reimbursement is going to be based on your ability to substantiate what that leave was, so make sure collecting information. We don't have time today to talk about the PPP, but that's another big issue that you want to make sure you're collecting your information. We talked about staying up to date. And don't forget the fundamentals. Don't forget that those of you that are covered by the FMLA is still going to apply to people who need that type of an accommodation or that type of leave of absence. So be aware of that. You still need to process it. I want to invite you to visit Fox's Coronavirus Resource Center. We have some wonderful alerts and articles, and it's very up to date. Those of you that have filed for PPP money and have received it, there's some new information from the SBA that came out yesterday. You will be able to already find it on our site. So please feel free to log on and list yourself for updates. This is about our firm. We're 950 lawyers in 70 different practice areas around the U.S. We'd love to be your lawyer if you need one. And we thank you for attending with us today, and we thank the BDB for sponsoring this and for being there and continuing to offer their town halls and all their other communications. So we thank you. We're at 1:01. We're going to print out the rest of your questions, and either Heather or I will be back in touch with you. So thank you again for attending. Have a good day.